King Charles has sent Prince Harry a formal financial demand exceeding $59 million. Legal sources confirm the figure is tied to royal security costs, property settlements, and withdrawn funding. At the same time, financial records indicate Meghan Bernardo Markle had already moved to liquidate jointly held assets before the demand arrived. Harry now faces the bill alone. What happened to the money? And who made the decision to leave him exposed? In January 2020, Prince Harry and Meghan Markle stepped back from their roles as senior working members of the British royal family. At the time, the palace described the separation as a transition. A new arrangement was being formed. The financial details, palace officials said, will be worked out privately. For several years, those details remained behind closed doors. No public figure was attached to the costs Harry had accumulated during his time as a working royal. No specific sum had been confirmed. But that changed when a formal financial demand was directed toward Prince Harry, carrying a figure that sources place at $59 million. The demand did not appear without warning. According to reports, royal financial advisors had been signaling for months that a formal accounting was coming. Preliminary notices had been delivered to Harry's representatives. Opportunities to settle the matter quietly had been available. None of those opportunities produced a resolution. When private negotiation failed to reach a conclusion, the demand moved to a formal channel. That shift is significant. When a financial matter between a royal institution and a departing member moves from informal discussion to a formal documented demand, the nature of the situation changes entirely. It is no longer a family disagreement handled through private correspondence. It becomes a structured legal and institutional claim, one that carries weight, deadlines, and consequences. So what exactly does the $59 million figure represent? According to sources familiar with the matter, the demand is composed of several distinct categories. The first and largest component relates to royal security costs. When Harry and Meghan departed the working royal family, they also departed the formal security structure funded by the Crown. For a period following their exit, protection arrangements continued under various frameworks, some transitional, some negotiated. Those costs, sources say, were tracked and retained on the royal ledger. The accumulated figure from that security provision forms a central part of the current demand. The second component involves Frogmore Cottage. The property, located on the grounds of Windsor Castle, was renovated at significant public expense before Harry and Meghan took up residence. Reports at the time placed the renovation cost at approximately £2.5 million. When Harry and Meghan were formally asked to vacate Frogmore Cottage in 2023, questions about the renovation expenditure and any outstanding obligations tied to the lease arrangement were left unresolved. That figure is believed to be included in the overall demand. The third component involves withdrawn sovereign grant allocations. As working royals, Harry and Meghan received funding through the sovereign grant, the mechanism by which the Crown funds the activities of working members. When their status changed, that funding was suspended. The palace's position, according to sources, is that certain expenditures made on Harry's behalf during the transitional period had not been recovered. Those figures are part of the formal claim. The fourth component involves legal cost recoveries tied to the broader process of Harry's departure. The legal framework for leaving the working royal family is not simple. Negotiations, agreements, and documentation all carry costs. Several rounds of legal work were conducted at the institution's expense. The palace has indicated that a portion of those costs should be attributed to Harry directly. When these components are combined, the figure reaches the range sources have confirmed. It is a large sum, but from the palace's perspective, it is not an arbitrary number. It reflects documented expenditures made on Harry's behalf over a period of years, expenditures that were never formally settled through the private channels available before formal action became necessary. The timeline of the demand carries its own meaning. Why did formal action come now and not earlier? That question has not been answered by any official source. Palace officials have not issued a public explanation for the timing. Harry's representatives have not confirmed or denied the existence of a demand in full. The silence on both sides is notable, but does not change what the documents show. What the documents show is a formal financial claim, structured with legal precision, directed at a man who left the institution with very public statements about his reasons for doing so. The claim does not engage with those reasons. It addresses only the financial record. The story does not begin or end with the bill itself. It begins with what happened on the other side of the ledger and who moved first. Before the royal financial demand reached Prince Harry in formal terms, a separate set of financial decisions had already been made. According to investigative financial reports and sources with knowledge of the couple's business arrangements, assets that had been held jointly or under shared legal structures were moved, converted, or repositioned before the formal palace claim arrived. Understanding what those assets were requires a brief look at how Harry and Meghan structured their finances after leaving the working royal family in 2020. They arrived in the United States with a series of high-value commercial agreements in place or in negotiation. These included a reported $100 million content deal with Netflix, a podcast arrangement with Spotify, a joint memoir project, and a range of public speaking and appearance agreements. Not all of those agreements were structured identically. Some were held under joint arrangements. Others were registered through production companies and limited liability structures that gave one party controlling authority. The specific legal architecture of those arrangements matters because legal architecture determines who can act and who bears exposure when a financial challenge arrives. According to reports, in the period leading up to the formal royal demand, financial movements occurred within the structures that housed the couple's commercial assets. Assets held under shared or joint arrangements were repositioned. Accounts tied to production entities saw activity. Legal filings in California, where the couple is based, reflected changes in the ownership structure of certain business vehicles. The timing of these movements is what draws scrutiny. Sources familiar with the financial record indicate that the repositioning of these assets preceded the formal royal demand by a traceable window. That window, according to reports, falls within a range of weeks to months before the palace claim was formalized in writing. This chapter presents that timeline as it appears in the documented record, without assumption about intent. What the timeline shows is a sequence. Meghan's side of the financial structure moved first. Harry remained in place. When the royal demand arrived, the assets that might have been considered shared resources and that might have been applied toward a joint financial obligation were no longer in a position to be used in that way. The specific assets involved include real estate holdings the couple had invested in or held as part of their California life. Reports indicate that certain property interests were transferred or restructured. Commercial contract rights, including those tied to the production entity used for the Netflix deal, underwent changes in registration and control authority. Brand agreements connected to the couple's public profile were also reviewed and in some cases redirected. Spotify's relationship with the couple had already ended by this point. The Archetypes podcast, which launched under the Archwell Audio brand, was not renewed after its first series. That revenue stream closed. Netflix's arrangement was narrowed in scope compared to the original reported figures. What remained of the commercial income portfolio was smaller than it had appeared at the outset. Within that reduced portfolio, the documented movements show that controlling authority shifted. Who held the rights? Who controlled the contracts? Who was the named party on the relevant entities? Those details, as reflected in public filings and confirmed by sources, shifted in ways that left Harry with less direct access to shared financial resources than he had held before the palace demand arrived. This chapter makes no judgment about why those movements happened. People restructure their finances for many legitimate reasons. Business decisions change. Legal advisors recommend reorganization. Tax considerations drive structural changes. The record does not show intent. It shows outcome. The outcome was that when the palace's formal $59 million demand reached Harry, the financial landscape around him had already changed. Assets that existed before the demand were no longer positioned where they had been. The exposure, the direct legal and financial obligation, remained in Harry's name. The question that follows from this sequence is not a simple one. In a legal and financial framework, who bears responsibility when one partner in a shared commercial venture moves to restructure before a joint liability arrives? That question has an answer, but the answer depends on when knowledge of the incoming obligation was held, and by whom. Whether Meghan knew the formal royal demand was coming before it arrived has not been confirmed publicly. But the timing of the financial movements and the documented outcome of those movements is not in dispute. The structure had changed. Harry stood exposed, and the palace bill was already on its way. To understand how Harry reached this position, it is necessary to go back to 2020, when Harry and Meghan announced their intention to step back from the working royal family. They also announced their intention to become financially independent. That word, independent, carried weight. It was used deliberately and publicly. It signaled that the couple did not intend to rely on crown funding, royal structures, or institutional support. Financial independence requires a financial plan. Harry and Meghan arrived in the United States with one. It was built on a set of commercial agreements that, at the time of signing, represented a significant total value. Reports placed the combined commercial opportunity at or above $100 million across all agreements and projected income streams. The centerpiece was the Netflix deal. Announced in September 2020, the agreement gave Netflix the rights to develop content through a production company registered under the name Archwell Productions. The reported value of the deal was between $65 and $100 million over a multi-year term. The structure placed Archwell Productions as the producing entity, with Harry and Meghan as the named creative leads. The Spotify arrangement was announced shortly afterward. Under the Archwell Audio brand, the couple signed a deal to produce podcast content. The reported value of the Spotify agreement was around $18 million. Meghan launched the Archetypes podcast under that arrangement in 2022. It ran for one season before Spotify declined to renew. The partnership ended in 2023. In parallel, Harry signed a book deal with publisher Penguin Random House. The memoir, published under the title Spare, was reported to have earned an advance in the range of $20 million. That agreement was structured in Harry's name individually, separate from the joint production vehicles. It was his obligation alone, and his income alone. Public speaking arrangements were also developed. Both Harry and Meghan joined speaking agencies and began appearing at corporate and nonprofit events. Individual speaking fees for figures of their profile typically range from tens of thousands to several $100,000 per appearance. Those income streams were structured as individual engagements rather than joint commercial agreements. They generate income, but they do not generate the kind of sustained, contractually guaranteed revenue that a multi-year platform deal provides. The legal architecture underneath all of this is important. Archwell Productions, the primary vehicle for the Netflix content deal, was registered as a California LLC. In California, a limited liability company can be structured with one or more managing members. The managing member or members hold decision-making authority over the entity's contracts, bank accounts, and legal commitments. Who holds that managing authority determines who can act when the entity's direction needs to change. California is also a community property state. Under California community property law, assets acquired during a marriage are generally considered to belong equally to both spouses. This principle applies to income earned, business interests acquired, and in many cases, assets held through business entities if those entities were funded with community property funds. The application of community property law to complex business structures is a matter of ongoing legal interpretation. But the baseline principle is that marriage creates shared ownership of assets built during the marriage. This legal framework has direct relevance to Harry's current situation. If the couple's assets are subject to California community property rules, then financial claims directed at Harry, including the royal demand, may theoretically have a reach into assets that Meghan also holds an interest in. Conversely, if those assets have been legally restructured, transferred, or separated through proper legal instruments, the community property framework may no longer apply in the same way. The outcome depends entirely on what legal steps were taken and when they were taken. What happened to the revenue that flowed through these structures is also relevant. The Netflix deal did not produce the volume of content originally anticipated under the multi-year term. The primary project delivered was the Harry and Meghan documentary series, released in December 2022. Subsequent projects were slower to develop. Reports indicate that Netflix's ongoing commitment to Archwell Productions was significantly reduced compared to the original agreement scope. The headline figure attached to the deal at signing did not reflect what was ultimately delivered or paid. Spotify ended entirely. The Archwell audio relationship was described by industry observers as a clean dissolution, with no renewal offered and no successor arrangement announced. That revenue stream, which had represented approximately $18 million in contracted value, closed without replacement. Harry's memoir generated substantial sales. But book advances, once earned out through sales, become ordinary income. They are not assets sitting in an account. They move through the financial structure of whoever received them and are subject to the tax and legal obligations of the individual holding them. Once spent or allocated, they cannot be recovered or reassigned. By the time the royal demand arrived, the income picture that had appeared robust in 2020 had contracted significantly. The combined commercial value reported publicly at the start of Harry and Meghan's American chapter had not fully materialized. What remained was a narrower set of revenue streams, restructured entities, and a legal position in California that was growing more complicated by the month. The architecture of their finances, built on assumptions of scale, duration, and joint effort, had not held in the form originally projected. The foundation had shifted, the revenues had contracted, and the royal institution's claim had arrived into that weakened landscape, targeting the one name still formally attached to the obligation. The question was no longer whether Harry could build financial independence. The question was whether he had enough left to answer for what leaving had cost. Prince Harry now faces a formal financial demand from the British Royal Institution. The figure is $59 million. The question is not whether the demand exists. The question is what Harry can legally do about it, and what resources he has left to work with. Legal analysts who have reviewed the publicly available information about Harry's situation identify several layers of complexity. The demand originates in a British institutional framework. Harry lives in the United States. Those two facts alone create a jurisdictional challenge that most ordinary financial disputes do not face. For the royal institution to pursue recovery of the full amount through legal channels, it would need to establish that the demand has standing in a jurisdiction where Harry holds assets. The United Kingdom and the United States do not share a single legal enforcement framework for civil financial claims. A formal judgment obtained in a British court is not automatically enforceable against assets held in California. The palace would need to pursue enforcement through American legal channels, which introduces a separate set of requirements, timelines, and costs. This jurisdictional layer gives Harry some structural protection, but it is not a shield. California courts can recognize and enforce foreign judgments under certain conditions. If the palace pursued the matter through British legal proceedings and obtained a formal judgment, that judgment could then be submitted for recognition and enforcement in California. The process is complex and slow. It requires legal filings in two countries. It requires coordination across different court systems with different standards of evidence and procedure. But it is not impossible. Courts in California have recognized and enforced foreign civil judgments before. The mechanism exists. The more immediate legal question is whether Harry signed any documents during his royal exit negotiations in 2020 that acknowledge financial liability for the categories of expenditure now included in the demand. The terms of the Sandringham Agreement, as the exit arrangement was informally known, have not been made public. Royal negotiations of this kind are conducted under strict confidentiality. Parties sign non-disclosure obligations as part of the settlement framework. The specific terms do not enter the public record unless one party chooses to breach the confidentiality or unless a court proceeding forces disclosure. But legal observers note that formal exit agreements of this type typically include provisions about outstanding financial obligations. Parties who sign such agreements typically acknowledge the framework for how those obligations will be handled. They agree to a process, even if the specific figures are left to later calculation. If Harry signed instruments that acknowledged liability for security costs, property obligations, or grant-funded expenditures, the palace's legal position in pursuing recovery is considerably stronger. The demand would not simply be a claim against a departed royal. It would be a documented obligation tied to a signed agreement. Sources have not confirmed what the Sandringham Agreement contains regarding financial liability. Harry's representatives have not addressed this point publicly. The palace has not released the documents. What the record shows is that the exit was negotiated over a period of weeks, with lawyers present on both sides, and that a formal agreement was signed. The contents of that agreement remain one of the most consequential unknowns in this financial dispute. The second legal dimension involves the asset movements described in the previous chapter. If assets that were jointly held or jointly funded were repositioned before the royal demand arrived, Harry's legal team may have grounds to argue that those movements should be considered when calculating his net exposure. Under California community property law, certain financial decisions made by one spouse that disadvantage the other, known in legal terms as the dissipation of community assets, can be subject to legal challenge within the marriage. However, raising that argument requires Harry to take direct legal action against Meghan. It requires him to place the question of who moved the assets and when, and with what knowledge, into a formal legal proceeding. That step would be extraordinary. It would mean a husband filing a legal challenge against his wife over financial decisions made during the marriage. It would create a public legal record of a financial dispute between two people of extraordinary public profile. It would require the disclosure of financial documents, entity records, internal communications, and potentially the terms of their commercial agreements with third parties like Netflix and Spotify. The consequences of that path extend well beyond the legal. It would fracture the public narrative both Harry and Meghan have maintained about their partnership. It would require each of them to engage lawyers acting in their individual interests, not their shared interests. It would become one of the most publicly documented marital financial disputes in recent memory. Neither side has taken any step in that direction publicly. But the legal option exists, and the fact that it exists changes the calculation on both sides. Harry's third option is negotiation. The palace's formal demand does not necessarily mean the palace wants a public legal confrontation. Royal institutions historically prefer quiet resolution to visible conflict. The formal demand may be designed in part to compel Harry to engage in a structured settlement negotiation that he had been deferring or avoiding. A negotiated resolution, reached privately and documented without public disclosure, would allow both sides to close the matter without court proceedings. But negotiation requires resources. A settlement figure, even a reduced one, requires Harry to have liquid assets available or income streams sufficient to support a structured payment arrangement. A payment plan spread over several years might reduce the immediate burden, but it still requires a starting figure, a demonstrated ability to meet ongoing obligations, and a legal framework that both sides agree to honor. Given the current state of Harry's commercial income, reduced Netflix relationship,